Welcome, everyone. Thank you for joining us for today's webcast, How to Maintain Your Employees' Biometric Information Privacy and Avoid Liability with Confidence, sponsored by EPAY Systems. This webcast has been pre-approved for HRCI and SHRM credit. Please be sure to attend the complete webcast in order to receive your credits. If you have any questions during the webcast, click on the Q&A tab in your webinar controls and type them there. I'll post a link to the slides and the exit survey in the chat area once the presentation has started. A new tab will open in your browser with the webcast survey. Please be sure to complete it as soon as the webcast is ended. It is now my pleasure to turn it over to our presenters, Jennifer Long and Michelle Lanter-Smith.
Hello, everyone, and this is Michelle Lanter-Smith. Welcome to our webinar today, How to Maintain Employee Biometric Information Privacy. So glad that you could join us. I am the Chief Marketing Officer here at EPAY Systems, and at EPAY, we are a full human capital management solution provider. We specialize in time and labor management, and that has been our history, and one of the reasons why we are hosting and presenting this information to you. Today with me, we have Jennifer Long from Duane Morris. If we can go to the next slide, we can see our photos up there on the screen and get to know us a little bit more. Jennifer Long is with Duane Morris. She is an attorney there, and she practices management-side employment law with a focus on prevention of workplace-related issues. Jennifer has a proven track record of working with businesses and operation leaders to provide prompt practice and efficient resolutions of employee concerns and workplace issues. She provides legal counsel on all aspects of employment law to clients ranging from startups to local mid-market companies to major multinationals. We here at EPAY have worked with Jennifer before. She's part of our regular series, and we're so glad to have you with us, Jennifer. Welcome.
Thank you. It's my pleasure.
Before I turn it over to you, Jennifer, let me just go through the agenda real quickly. On the next slide, you can see what Jennifer's going to go through. Now, we here at EPAY talk about this topic quite a bit, and we talk about biometric privacy and are very concerned with it, making sure that our systems can provide that type of level of security for you as the employers, and that your employees feel comfortable with the biometrics that are being stored and are being used. But there's a lot of things that go around this, and this is a very heated and common topic in today's world. Thus, that's why we have Jennifer here with us. So she's going to go through really what is biometric information, what is really the details of the Illinois Biometric Information Privacy Act, things that you need to do, and of course, a good question and answer session so you can ask your questions. But first, on the next slide, I'll tell you just a little bit more about EPAY Systems. We have been in the human capital management space since 2001. We are a provider of a completely unified human capital management solution. So that's applicant tracking to onboarding, HR, time and attendance, payroll, and even performance management. Where we specialize, however, are with hourly complex workforces. So those are employers that have their teams moving around from site to site, customer to customer, a lot of shift differentials, a lot of union rules, things going on. That's a really hard workforce to track and a hard workforce to pay. And that is the kind of workforce that we love to really serve. We have been doing that for, well, almost 18, 19 years now. But what we really specialize, besides just a full suite, is where people, why they choose to go with us, and you can see some of the logos down below, is because of our time and labor management solution. If you're going to serve that space that I just talked about, you have to be very strong in time and labor, and your solution has to be very robust. So flexible payroll engines, flexible communications, the ability to get started very easily without much IT resources. We do that, and we also provide great customer support. As you can see with our customer retention, we provide all of our customers with 24/7 support. And that's why a lot of the clients, again, that you see at the bottom of the screen, why they like to work with us. And we hope we get an opportunity to work with you too. But now it's time to get on to our topic. So I'm going to turn this over to Jennifer. Again, thanks, Jennifer, and look forward to hearing what you have to say.
My pleasure. Thank you so much, Michelle. It's always great to work with EPAY and your clients. We too, here at Duane Morris, have a large footscape across the United States, having offices in 19 locations located all across the United States. What that means then is I get to work with employers of all sizes and shapes, as I like to say, that operate in all sorts of different industries and have all sorts of different security concerns. And one of the most recent things that has come up with those type for my employers of all sizes is the idea of using biometric information as a security measure for one reason or another. So today I'd like to spend some time talking to you folks in HR about what your compliance obligations are and how to meet them under not just certain laws for your jurisdiction, but things that you may not yet be aware of. And so don't let those fingerprints convict you in HR, and let's get started. So let's start off first by going through the basics. What is biometric information, and why is it such a big deal? Why are we talking about it all of a sudden with such enthusiasm in the legal arena? Simply put, biometric information is obtained from any scan or collection of a person's individual characteristics. It's any metric, and that metric can be any sort of quantitative measurement or indicator or data that's related to a human feature. It means that that information is unique. It is largely permanent. We'll talk a little bit about that in a bit, and it's collectible. It has to be all of those things to be considered biometric information. However, we'll spend a lot of time talking today about how biometric information is defined is different under each of the laws that you may be subject to. And so specifically, then, what does that mean? Biometric information includes things like retina and iris scans, and we've got a good example of one there. Fingerprints, which is probably the one that's most commonly thought of, that you're most aware of. Palm prints or hand scans. You tend to see those, quite frankly, a lot in your international espionage types of TV shows and movies. You always see the character doing a hand scan or trying to get around the hand scan at a security feature in a vault or something. Voice prints are also biometric information because the cadence of a person's voice is unique to the individual. And facial scans, so a scan of the entire part of your face. Now that we know what they are, why are companies using them? The biggest reason by far is that they are thought to be more secure than your average everyday password. We have all been stuck, or I guess I shouldn't imply out to the entire audience, but I will sure fess up to, having to use that forgot password key on every website you have to log into all day long, too frequently than I'd care to admit. Passwords are hard. Every IT security expert out there is telling us to make them as difficult as possible to remember, quite frankly. And we are all too aware of what happens when there's issues when hackers get past those password systems. Or more recently, the biggest concern probably is phishers get past. P-H-I-S-H, phishers get past those password protected security points. And so companies and software and all sorts of IT functions and other functions are turning to the potential of using biometric information for your password. And the reasons for that are clear. Biologically, it's immutable. It's connected to you at birth. It's unique to the user. And are there exceptions? Sure. There's been some studies on twins, but even in those cases, it is still unique to the user. You can't forget it, right? You can't leave your eyeballs or your face or your palm or your fingerprints behind, unlike the crazy password scenarios that we've all dealt with. It can't change. And I will admittedly tell you that I've watched far too many of those international espionage types of movies where you have the CIA black ops getting around a iris scan or a facial scan and using all sorts of ways to get about that, or the internationally wanted criminal undertaking medical changes in order to change their facial structure. More commonly, in fact, if you Google it, it'll come right up, are the criminals that believe that burning off your fingerprints results, or injuring your finger on its pad, for instance, by a knife cut, results in a mutation of your fingerprint. We're going to leave all of those kind of Hollywood-esque circumstances aside. Are there some possibilities of changing, of having exceptions to what I'm talking about? Sure, those are few and far between, and like I said, mostly the lore of Hollywood movies. But for the most part, in the business environment, biometric information is thought to be unchangeable, and therefore makes it hard to duplicate, meaning that it makes it hard to get around the security features that depend on the biometric information. So I'd like to take a moment here, just as we get started, so that we can all learn about each other and talk about, take a little poll of whether your company is using biometric information right now. And the options for your response are up there. No, we aren't using biometric information yet. Yes, we're using facial scans. Yes, we're using fingerprints. Yes, we're using retinal or iris scans. Yes, we use palm scans. Or yes, we use something else. So take a minute, and we're going to give, I don't know, 30 or 45 seconds for everybody to get in and just click one of those boxes. Don't worry, we're not capturing the results. We're just using this so that we can see what all folks on the call are doing, and more importantly, how that pans out into the rest of the world. So we have some results back here from you, and by a large margin, 50% of you have responded that you aren't using biometric information yet. So good on you. Way to be in front of what will be a serious compliance area for you before you've gotten started. As an employment and HR lawyer, I'll tell you that that's not always the case. In fact, some of the bread and butter work that I do is dealing with folks that didn't take their compliance concerns into account before adopting new technology or new things to the market. And so good for you. I will tell you that out in the world of biometric information, the most commonly used one is fingerprints, followed kind of neck and neck by facial scans and retinal scans. So once you are using biometric information, what have you intended it to be used for? Anything where you need security to be greater than when you use a password. And so what are the most typical things that it's used for? Definitely anyone that has a smartphone or tablet at this point should be familiar with the fingerprint technology, for instance, for iPhones and iPads. You're pressing your finger to the screen and now also using facial recognition on your iPhones. So a lot of us are using that without even thinking about it. Security access. So at the doors, both at the exterior of your building and then for you in high-tech, high-security areas for access points within your buildings. You'll particularly see it with regard to even in buildings that don't have high security issues with regard to your IT closets. EPAY will certainly chime in, I'm sure, and confirm that time clocks are one of the highest areas of use for employers that have a high volume of hourly workforce. Using either a fingerprint or a facial scan software is definitely being sold in the marketplace as a way to secure your time clocks and your time punches. We see it for electronic purchasing, fingerprint systems at purchase points, same thing with logging into banking and finance accounts or information, and then for IT network security. And so let's take another moment, and for those of you that are actually using biometric information, or let's throw this out there, let's make it even broader. Those that are actively considering using biometric information, what are you intending to use it for? Physical or building security access, time clocks, IT network security, electronic purchasing, banking and finance logins, or other things that we haven't thought of yet. So we'll, again, use a few seconds here to allow more people the opportunity to jump onto that poll there so we can see what your network here on this call is using it for and where you fit in the world at large. Here we go, and we're getting the response back. So interesting, definitely, and I rather expected this on a call sponsored by EPAY. Time clocks, 58% of you are using it for time clocks, followed by, but quite a ways behind, by physical and building security access. Laptops, 10%, other, always curious about the other, is 13%. So that is not unusual. That does match the market or the world at large. I would say, though, that building and physical security access is probably the #1 use out there if you're looking at biometrics at large, not only in the employer context. So we have a call here that's made up of HR folks from employers. If I expanded this call out to people in the business community at large, physical security would be #1, followed by time clocks. Okay, so now that you are using it or you're thinking about using it, what are some of the risks involved, and how can we help you? How can we try to limit those risks and keep you in compliance with all of your obligations? So some of the concerns are the same as with any other password protected item. Hackers. Hackers, you may think of biometric privacy as unhackable because it's not a series of digits or letters or symbols put together that a person with code can sit and work around. However, it does have to be stored somehow in the IT software that's connected to it. And so anything that has to be stored, hackers can find and manage a way around. That is the reality. People that want to do wrong will find a way to do wrong. The thought is, though, that some of the benefits of biometric privacy can also be an issue. For instance, your biometric information, the metrics of your face, the metrics of your fingerprint can't be changed. I can't change my fingerprint, with the very limited exceptions that we talked about earlier, in the case that it's been hacked. So if there is a violation, if there is a security breach of the actual biometric privacy information, it is not as simple as going in and changing all your passwords on all of your accounts to something new. And they can be duplicated. Again, in the real world, outside of Hollywood and international espionage, it's rare, but they can be duplicated. through some of the same bad actor techniques that the hackers and others have used in other scenarios. And once they are compromised, unlike passwords that, again, you can simply go in and wipe out and start fresh, it is hard to fix. So those are some of the concerns. And then the primary one from a legal liability standard is your compliance requirements. You have compliance requirements under many different areas of law. That's what we're going to spend the majority of our call going through. And it can be difficult for multi-jurisdiction employers to make sure that they are complying with all the things they need to comply with in this area, just like anything else in HR. And then additionally, you have liabilities where you are using biometric information for failing to secure it. So once breached, your liabilities for breach are similar to those that you might face for any other breach of data. So let's get started on your compliance law obligations under various biometric information privacy laws. You and HR are very well aware that employers have multi-pronged compliance obligations in so many areas that we deal with. Leave of absence, you have to comply with FMLA, but also state and local laws. Wage and hour issues, FLSA, state and local laws as well. It happens in almost everything you're doing. This is no different. Let's go through where your main issues lie and give you the outline of what you need to be aware of. So first things first, we have state biometric privacy information laws. And we're going to spend a good portion of our time together on that, specifically under the Illinois law, the one that was first in its class in that area, the first to be passed way back in 2008, and the one that is giving employers by far the most grief from a liability standpoint right now. There are other state biometric privacy information laws that have a lot of similarities. Texas and Washington were passed in 09 and 17, but Illinois by far, because of the uniqueness of its liability provisions, has been giving employers the most grief, and we'll talk about that. Then you also have state data breach notification laws. Those were passed en masse, starting in probably the mid-2000s. In particular, things heated up in around the 2008 timeframe, same time as the passing of the Illinois law, when massive data breaches were out there of credit card companies, payment processing companies, health insurance companies, mortgage loan companies, you name it. We all can name one of those huge data breaches that occurred, and all the notices now that you receive all too frequently when some item that you are subscribed to or that has your personal information has suffered a hacking breach. Well, those are governed now under state data breach notification laws that say specifically what a company must do when data that they are holding for a consumer, or in your case, an employer, an employee, must do in the event of a breach. Then you have what we call general privacy laws. The two biggest ones, the newest one is the California Consumer Privacy Act, which hasn't even gone into effect yet and yet is giving people struggles. And then the one that you probably have heard more of and have probably taken steps if you have any connection to the EU with regard to your company's operations, the General Data Protection Regulations, the GDPR, which is the EU privacy law. So we'll talk this, unfortunately, neither one of those laws, the California Consumer Privacy Act or the GDPR, they are substantial laws that have a huge amount of compliance obligations that deserve their own time. So we won't spend detailed time on those. I can tell you that you should be considering your obligations under those and make sure you're complying and looking for additional education on those topics. For instance, the CCPA Act, Duane Morris is running has just started a multi-part series. You can look for information on that on our website if you're interested in joining on your obligations under that law. Same thing can be said for GDPR, but you should be looking for your responsibilities and complying with those. I will touch on them briefly today. And then one more set that a lot of companies haven't even considered is that you have unique requirements, unique laws that apply just to particular industries or just to particular uses of data that give you additional requirements. HIPAA, of course, is the most forefront in anyone's mind that has ever gone to a physician and had to sign off on a HIPAA privacy statement. So healthcare is probably one of the biggest industries that has its own personal privacy act. But there's also ones that drill down for even more specific employers. For instance, DCFS, or your state's version of the Division of Child and Family Services, has obligations with regard to child protective service data. And of course, the credit and finance industries have all of their industry laws and regulations that apply with equal force to data privacy issues. So let's go through the Illinois Biometric Information Privacy Act. And I know some of you are saying, well, I'm not in Illinois, or I don't do any work in Illinois, I don't have any employees there, we don't do business there, why is this of concern? It's good to know regardless, because the requirements of the Illinois Act are not unique. The general concepts are the general concepts that apply under many of these laws. You still have to make sure you are specifically compliant under whichever law applies to you, including the GDPR or the CCPA, as those may apply. But what I'm telling you about Illinois will be helpful, especially since I see our audience is in that 50% not yet using biometric information area. This will allow you to be an informed person in the room when you go back to your management teams and ask them what they are doing and whether they are considering using biometric information. So the Illinois law was the very first in the country back in 2008. It had passed with very little fanfare. I've been doing this area of law for over 20 years, and Duane Morris runs an annual client information seminar on hot employee issues. And I can tell you that I went back and looked at my slides from the spring of 2009 presentation. And this got a blurb, but that was it. It was followed very quickly by a Texas law in 2009. And then you see, very interesting, nothing else for another 8 years until Washington State passed a law. And that's basically where we stand. There's been a number of states that have introduced the laws, but nothing other than, for instance, the California law that we'll talk about has been passed to date. What does the law do? It regulates all private entities, including employers, use and collection of biometric information. And why was it passed? Because the legislature was specifically concerned with the heightened risk of identity theft that they believed came from use of biometric information. And again, this was all in the context of a vast number of data breaches that we started hearing about in the mid-2000s. And I've given you this citation there just in case any of you need any light bedtime reading. And so what is a biometric identifier under the Illinois Act? It's similar to what we've already talked about. It's specifically named retina and iris scans, fingerprints, voice prints, hand scans, and face scans. And then what does it cover? What is it requiring? It covers any information or data, regardless of how it was captured, converted, stored, or shared, that's based on any biometric identifier. Washington has the same provisions. Texas is a little easier on companies and employers. It's just those specific biometric identifiers. So just the fingerprints, just the face scans, just the iris scans. It's not this broader term under Illinois and Washington that says it's anything based on the scans. In Illinois, it includes information that's been converted into code or templates. A lot of employers that have had issues under this law say, well, we don't hold any fingerprints. It's all converted. Doesn't matter in Illinois. You took the data originally. However, they do specify in the law that it does not include an employee's signature, photograph, demographic data, tattoo descriptions, or a physical description. So it is limited to the things that can be scanned into personally identifiable metrics. And so what's required of employers? This is where the liability really attaches. It specifically requires a written notice and signed consent if an employer does anything, captures, collects, purchases, receives, obtains any biometric information or any information based on a biometric identifier in advance of that collection. And so what does that mean? Here we go. These are the requirements that are set forth in the Illinois statute. The written notice and consent has to consist of and include the following. You, as an employer or company, have to develop a written, publicly available policy that includes, at a minimum, the retention schedule for the data, the biometric information that you've collected, and specifies guidelines for when that data will be permanently destroyed. The statute says that that guideline should be connected to the purpose of the use for the biometric information. So when either that purpose of the use has been satisfied, or a maximum of within 3 years of the employee's or person's last transaction with the company. And so what does that mean? If you are using it for a time clock, the maximum time that you should retain it before a permanent destruction should be 3 years from the employee's last time clock entry. Same thing for security, etc. If you were using it for some specific project and that project has concluded, then that may be another time for permanent destruction. Okay, 2, you have to inform each employee in writing that the employee's biometric information is being collected or stored or used. You have to tell them what the specific purpose of the collection is and how long it will be collected for. So we are using your biometric data. We are collecting it in connection with our time clock system or our security building access system, and we will be retaining it throughout your employment and for a maximum of 3 years after your employment with the company ends. 3, you have to obtain an employee's written executed release and permission that may be required as a condition of employment in connection with the use. And then what are employers' obligations generally with regard to the data that you collected? Illinois says you cannot sell it, lease it, trade it, or otherwise profit from that information. You can't disclose, redisclose, or disseminate it without specific consent for that disclosure, redisclosure, or dissemination. There's very few exceptions to those requirements. you have to store, transmit, and protect from disclosure using a reasonable standard of care within the employer's industry. So whatever you are doing to protect it must match up to a reasonable standard of care that you otherwise use within your industry to protect confidential data. So in at least as protective a manner that you store other confidential or sensitive information. Unlike Illinois, that doesn't provide much helpful exceptions for anything under this law, Washington State does have a helpful exception that excludes information, that, biometric privacy information that was retained by employers for security purposes. So you may have some help out in Washington. Neither Washington nor Texas are as restrictive as Illinois on these state laws. And here are the kicker. Why do I care, Jennifer? This is why. Each violation under the Illinois Biometric Information Privacy Act, it can be attached to a $1,000 per violation liquidated damages penalty, or actual, should you be able to prove actual damages, or up to $5,000 in the event that the employer is found to be intentional and reckless in their manner of complying with the law. And the real reason why everybody's interested in this act now is that Illinois, unlike some of the other statutes that we're going to talk about, gives employees a private right of action, meaning an employee that figures out that an employer does not have the things I talked about, the written policy and the signed executed release and authorization, can go to court and sue an employer just on that basis. There needs to be no other facts whatsoever. I've been required to use my biometric privacy information. My employer does not have a policy and did not obtain my written authorization. Please give me $1,000 per violation. And remember, with a time clock, that's 4 violations a day. In the morning, out for lunch, in from lunch, out in the evening. Security, it may be even more if they're going in and out of multiple doors all day long. Not just for me, Joe Smith, but give it to me, Joe Smith, and I am suing on the behalf of myself and a class of similarly situated employees. Meaning I, Joe Smith, am suing for every employee that has been in a similar position using the same biometric information with the company. A court is allowed to award what's called injunctive relief, so they can order a company to comply. And then this is the one that has gotten the plaintiff's bar's attention. Attorneys' fees and costs are available to the successful plaintiff. The Attorney General can also seek to enforce it. Quite frankly, I don't think we've seen any cases in Illinois where the Attorney General has chosen to do so. And again, Washington and Texas are much more lenient on employers. They only provide for civil penalties in the event that the Attorney General's office seeks to enforce it. And so damages can be significant. Damages can reach $1 million plus easily, even in the smallest of class action. In class action, it only involves 20 or 30 employees. Easily hit $1 million, for instance, through fingerprint timekeeping, door security, or any facial recognition software, because you have those multiple violations per day per employee, and they add up very quickly at $1,000 or $5,000 each. So why are we talking about this? Jennifer, this has been on the books since 2008. So why are we just now talking about it in such thoroughness? Well, we talked about it before, but nothing happened. The law largely lay dormant, even here in Illinois, where it was passed. Nothing happened. There were no cases brought under this law until the mid-2010s. And what happened then? The plaintiff's bar found it. I think us in HR are very familiar with the plaintiff's bar in the wage and hour context. Seeing lots of huge, enormous companies being sued for various wage and hour compliance violations, clock in, clock out issues, whether employees have been allowed certain things that they're entitled to under state law, like perhaps seating, for instance, in California, in the retail environment, things like that. We're all familiar with those. Those hit the front page of the newspaper. These cases didn't really arrive here into Illinois until a plaintiff's bar member found the law, quite frankly, found that it had an attorney's fee provision, and discovered that there wasn't much to filing these cases. So in 2015 or so, we saw the first wave. The first wave of cases were against the big social media companies, Facebook, Shutterfly, Snapchat. And they weren't connected with actually using your fingerprint or something to sign into those apps by the user. It was suing them for their facial recognition technology. When those apps are using their facial recognition technology to label all your friends in your photos, that was a violation of the Illinois law. So that started. 2016, we started seeing more kind of land-based companies, if you will, get brought into the fold. LA Tan was a big case here. It had 37,000 class members that used fingerprint swiping to sign into their LA Tan club. There was a settlement in 2016, $1.5 million. The actual class members only got $150 each. So far, far less than just one violation of $1,000. But there was a substantial amount that went in attorney's fees. And that's the way class actions work and why they're driven. 2017, we started seeing employers targeted. And now in 2018 and into 2019, we're seeing even the smallest employers targeted. Small meaning less than 150 employees over a couple of sites. So we're talking about it because right now there are over 200 pending class actions here in Illinois. I'm just giving you one example of a time period between June of 2017 and 10 of 2017, June and October of 2017. So just one 4-month period, for example, 30 class actions were filed. In 2019, more closer to the present, we've already seen 60 state court actions and 30 federal, just on this law. And more laws in this area are coming. They've been introduced in all those states you see on your screen: Alaska, Arizona, Connecticut, Delaware, Florida, Massachusetts, Michigan, Montana, New Hampshire, and New York City. And so this is not the end of the wave. We will see more requirements coming. We thought we were going to get some relief here in Illinois. There was a case that was taken before our Supreme Court, Rosenbach versus Six Flags. Six Flags Great America is our local amusement park just outside of Chicago. There was a teen guest, Rosenbach, the plaintiff is his mother, who visited in 2014, and at the time, I can confirm, because I took my children there frequently, when you bought a season pass, they required you to use a fingerprint to get in and out of the park with your season pass as a security method. I know other amusement parks across the country did the same. Well, in Illinois, no, they just made you use that fingerprint at the gate. They didn't give you any paperwork. They certainly didn't have you sign anything if you bought your ticket in a particular way, meaning like it was an upgrade at the gate sort of thing. So the question presented to the Illinois Supreme Court was, is a mere technical violation of the act sufficient to support a class action complaint? Because employers everywhere were arguing that that's it. It's just a technical violation. There is no actual damages suffered by anybody in any of these cases, because we have not gotten to the point yet where we have any case where a person says, yes, you took my biometric information privacy without permission, without express written permission, and it was unsecure, or it was hacked, or something nefarious happened to it. We don't have that. None of these people can allege that because it didn't happen. And so the question presented to the Supreme Court was, does that matter? And employers everywhere and legal pundits thought that we were going to get a good ruling. And alas, we did not. In January 2019, the Supreme Court came out with its ruling saying no actual injury is required. That's the way the statute's written. That's what the legislature must have intended. The statute is unambiguous. All you have to do is say that you didn't comply with the act. So what's going to happen? We're going to see far more cases. The cases I talked about in 2019, the 60 state court actions and 30 federal, are a result of that ruling coming out. There was a bit of pause in 2018 while that case was pending, and now we'll be on a roll again. So what else do you need to comply with? I mentioned the GDPR. Many of you have probably heard more about that law. It's been around for a while now, where you have any connection to the EU. It's the European Union privacy law that has data protection and security rules that require data controllers, that includes an employer, to comply with requirements for processing any personal data. Personal data includes biometric information, and even though it's an EU law, it can apply to US companies very easily. If you have any employees in the EU, so if you have a salesperson over there, even if your company does not operate in the EU otherwise, you likely are covered under the GDPR. If you have any processing of data that involves the EU, either you are processing here in the United States data that originated in the EU, or there is some EU entity that is processing data for you, even if the data is from the United States, you may be covered by the regulation. And then here's the kicker for most companies and where it comes into play for anyone that has a web presence. If you are targeting people in the EU by offering services. So any company with a web presence or sales presence often is caught by that kicker. What does it require? It has limits on the use of the data. It has specific consent obligations, and the persons having the data controlled have rights. Claims by employees are permitted. And what is the potential liability? Fines may be issued in the EU against a US company of up to $23 million US, or 4% of global revenues, whichever is greater. Again, this session today is far too short to go into all of your specific obligations, but if you do fall into the context of having any connection to the EU with regard to the company, I highly, highly urge you to seek additional information on the GDPR and your specific obligations. Similarly, we have the CCPA, the California Consumer Privacy Act. This one is brand new, really, and lots of you on the call may not be as familiar with that. You're just going to start seeing a lot of publicity and information out there about it. Basically, it's similar to the GDPR, involving requirements related to personal data. However, of course, its obligations are very specific to this law. It's a California privacy law that has data protection and security rules with requirements for processing any consumer personal data. Personal data can include biometric information, and quite frankly, for the first time, it's even broader than Illinois. Not to be unexpected if anyone is aware with California's laws, but it is broader than Illinois' Privacy Act in that it also covers things like body imagery. Think of the scan when you go through the airport scanner. That would be body imagery, anything like that. It can also include, for instance, sleep and health data. Things that are attached to your Fitbit or your other fitness tracker. That kind of data can be included. And it applies to any company doing business in California. And a lot of you are saying, oh, that's great. I'm located here in the Midwest or on the East Coast. I have no business in California whatsoever. Again, if you are web-based, you have a serious problem with that argument. It does have some criteria that may be helpful to for-profit companies, and there are some minimum gross revenue requirements. And what does it require? There's a right to know provision. There's a right to opt out provision. Basically, any consumer, including an employee, has there's limits on use of that data. You have a right to consent, and you have rights with what happens to your data. It is effective January of 2020. However, the rights have a look-back provision that goes back to July of this year, coming up in a month. However, there are currently amendments pending before the California legislature, and the guiding agency has said not to expect regulations that will help employers with their obligations until 2020. So that is a law that you will need to comply with, and you will need to look for information on that, but it's still in a changing mode. So there will be some changes coming forward. So keep on the ball on that one. And then we mentioned other data breach notification laws. By 2018, all 50 states now have data breach notification laws that require notification to consumers, which includes employees, when any personal data is compromised through some sort of hacking or other breach. And we think about it in hacking, but I'll be honest with you, most often the data breach calls that we handle here at Duane Morris involve, drum roll please, an employee leaving a laptop. The lost laptop, either you left it on the train or the plane and it had unencrypted spreadsheets on it, or the thumb drive, the lost thumb drive that didn't have adequate encryption on it, or it was just lost and unrecoverable. That is a data breach. Each state law has very specific requirements of what a company has to do to notify people that are at risk, and personal data under those laws definitely can include biometric information. It definitely does here in Illinois and in that list of states there. Problems there, the liabilities for companies, is that the violations are very specific under all those laws. Definitely you're going to be subject to an investigation by a state agency, and if you're found in a violation, there'll be steep penalties. Think $150,000 per violation and up. All right, Jennifer, you say that's enough. No more. I've had it. I already can't sleep at night because of all of our other issues that I'm dealing with. Let me tell you what you need to do now. So the first things first is the review and evaluation. I can't encourage you enough to go out and review and look at your data collection practices. Know your data. Review. Where are you collecting biometric information? Not just in HR, but all of your business units, all of your business operation functions. And have they made you in HR aware of it, or are they undertaking the notice and consent requirements themselves? What do your data policies say about biometric information? What is your retention schedule? And then if you are using it, are your notices, your written notices and your written authorizations, are they fully compliant with each law that applies to whatever data you are collecting? And have you looked that you have them in place for every employee that is having data collected? Many of you say to me, well, I have a great vendor. I have a great security vendor, a great time clock vendor that is providing all of that for me. That's fine, but make sure that you have reviewed and looked at the written notices and authorizations that they're providing as part of your package. And contractually, what are their obligations to you, for instance, in the indemnification provisions, in the event of some sort of breach, or in the event of a class action alleging that you have not fully complied. And then with retention, what is your vendor saying about retention? What are they collecting? How long are they retaining it? And does that match up to your internal employer policy for the same data? We talked about Illinois today because for the state laws here in the United States, generally Illinois has some of the most conservative obligations, meaning that if you comply with what Illinois requires, you have at least hit the hot areas of any other law. It doesn't mean that you're legally compliant anywhere else, but at least you've taken the first set of steps. In Illinois, you have to have that publicly available written policy, a written authorization from every employee that says specifically what's been collected, why, how long, when you're going to destroy it, reminds the employees of their rights, ensures that you aren't selling or disclosing it, and that you are taking a reasonable industry standard of care. And then finally, take a look at your vendor obligations. I talked about that. Check for their compliance and indemnification. Do not rely on the vendor's compliance. Make sure that you've looked at it internally. Also look at your other contracts where you are a vendor of someone else. What did that contract require of you as that company's vendor? And what indemnification are you providing to that company with regard to biometric collection of biometric information? Make sure you have protocols in place for obtaining the authorizations and then actually destroying the data on the date that you've identified, that you have a protocol and practice and employees in place that will respond in the event of a breach. And again, that you're making affirmative decisions in advance of using the biometric information. That you are actually deciding, yes, this is an area that we want to use biometric information, and not just doing so because a vendor or someone else throws it in as part of a package. So that we have reached the end. I see that some questions have popped up here. I'm going to start with those, but if anyone else has them, feel free to use the Q&A option on your screen. I'm going to do them all anonymously. Let's see, the first one. If a video recording equipment in use notice is posted, can that help to protect a business? That's absolutely great and definitely a requirement for video recording. However, the video recording laws are entirely separate from these Biometric Information Privacy Act requirements. So you will have obligations where you are doing video recording, and those will all be governed by state laws, but those are separate and a part of, and just an additional bonus for HR to comply with in that area. Good question. Let's see, we have a question specific to New York State. I will say up front that I am an Illinois lawyer. The question is, New York prohibits fingerprint scans unless an employee signs a voluntary consent form, but they do allow measuring the geometry of a hand, but not surface details of hands and fingers. Vendor says okay to do a finger scan. That is going to be something that is very particularly governed by your state law with regard to super specific exceptions. And so I'm happy to put you in touch with somebody in New York, because that ought to be covered under a New York colleague. So feel free to contact me directly. My contact information is there on the screen, and I can connect you with somebody in our New York office. And then, let's see, Hester, on this last one, it's an administrative question, I think, that I will leave for those that are wrapping up. I don't see any other questions right now, so unless they are, I think that brings us to our end.
Thank you, Jennifer, for this very informative webcast today. I'd like to, if the attendees would like to view this webcast again, the archive recording and slides will be available for up to 7 days for our free members and without restrictions for those with our certification membership. The webcast credit will show in your HR.com account within 2 business days, and we'll also send you an email with your credit information. Your feedback is important to us. Please take a moment to fill out the exit survey that opened in a new browser page on your computer. This concludes our webcast. Enjoy the rest of your day.